Welcome to the Jury Thinks What podcast. Part of the Lawyer Minds ecosystem, the Jury Thinks What podcast discusses everything there is to know about trying cases, from preparing the case before the lawsuit is filed, all the way to trial. And most importantly, how to understand what the jury is thinking. During our journey, we'll be talking to some of the brightest trial lawyers from many walks of life. What makes them successful? What makes them different? Do they have secrets to dealing with the jury? Let's find out. Here's your host of the Jury Thinks What podcast, Saul Gruber.
And welcome to the Jury Thinks What podcast. This is a podcast by trial lawyers for trial lawyers. Not only will our guests be those lawyers that are in the trenches every day trying cases and making new law, but our listeners and subscribers are those same trial lawyers in the trenches. We're here to address issues in litigation, in discovery, and during trial that a lot of lawyers who don't have mentors and aren't at big firms run into every day, and they really aren't quite sure where to get their answers. Well, that is why we are here. I am Saul Gruber, former trial lawyer from Gruber Trial Consulting, and we are here for the Jury Thinks What on the Lawyer Minds family of podcasts, along with our other podcasts. I encourage you to check our YouTube channel as well as subscribe to the podcast anywhere there is podcasts. And today I'm excited. We have two fantastic trial lawyers, Leah Barron from Brown Barron, as well as Elisha from Brown Barron. They are outstanding lawyers in the city of Baltimore, helping victims of abuse, lead poisoning, and nursing homes every day in the state of Maryland. Again, this is Saul Gruber from Gruber Trial Consulting on the Jury Thinks What, the podcast by trial lawyers for trial lawyers, and I'm pretty excited that we have both Leah Barron and Elisha here from it's Brown Barron, not Barron and Brown, right?
Right, Brown Barron. Brian Brown.
And I say that with love because Brian's going to be my guest in a few weeks, so I will do the same thing to him. In Baltimore, Maryland, and they're one of the premier trial firms in the entire city. And one of the exciting things at least on our podcast is we like to highlight the fact that some of the best trial lawyers in the world are women. And I personally don't think women get enough attention for that. I can tell you every time I lost a case, I can tell you a lot of times I've lost cases to women and they kicked my butt up one side and down the other. And there are a lot of reasons for that. And that's why I try to make sure that we make sure that everybody understands that. Later on in the podcast, in the season, we're going to have B.B. Fell. We're going to have Tori Shaw. We're going to have people that I respect the hell out of as trial lawyers. And here are two people that I love. Good morning. How are you guys today?
Good morning. We're happy to be here.
So, Leah, you are one of the founding partners of Brown Barron. Is that correct?
Yes. Brian Brown and I founded it almost 5 years ago.
Tell me about how that came about.
So Brian and I had worked together previously, and we had an opportunity essentially to take over someone's practice who was retiring. So we jumped on that opportunity, and we're lucky enough that we've made it work, and we've grown and evolved since then, and it's been awesome. And we acquired Elisha sometime last year. I can't remember exactly when, but that was a huge win for our firm.
Yeah. I mean, now, Elisha, you're a past president of MAJ. Is that right?
Yes.
Tell me what that means.
What does that mean? Well, it's funny. When I first joined MAJ as a board member, the board looked a whole lot different than it did when I was president.
I am sure it did.
Yeah. And I don't remember how many women presidents of MAJ came before me, but I'm pretty sure I can count them on one hand. And so it looks a whole lot different now. The president who just left MAJ was a woman, and we have a current woman president of MAJ. So it feels really good to lead an organization of trial lawyers with a diverse board that, we hadn't had in the past.
I've never understood people's and as you both know, I'm very active with AAJ and was on the executive board of the New Jersey Association for Justice. And I never quite understood why people objected to diversity, or they would say something when they're planning a seminar, well, I don't know any women trial lawyers. And I would say, well, have you looked around? Have you poked your head into a courtroom at all in the last 5 years? What explains that? I mean, what do you guys think really explains that?
I think it's like once people get, especially like when you look at an association like MAJ that's been around for a long time, and it came up under, mostly men, and it's hard to relinquish control of the organization to new people, whether they're women, men, or whomever. And so we've been working really hard over the past few years to put term limits in for the benefit of the organization. Like, listen, you've had your time, now help usher up a new group.
It's so important.
I think, right. And I think if people start seeing the benefit of that, you're going to see more diversity and more women just by nature.
And that's kind of, Leah, why we started this podcast, was to reach out to people. There are great lawyers that have podcasts. I listen to them every day. I always listen and read anything Keith Mitnick ever has to say. I will always read and listen anything David Ball has to say. But at some point in time, there's got to be some more voices. And those voices have to be out there for everybody, not just the most elite lawyers, but the person who's trying the 2-day car accident case in Baltimore County and is not quite sure how to do voir dire, or is not quite sure how to qualify an expert. And that's kind of what we put this together for, is the everyman's or the everywoman's podcast.
Yeah, I think that's awesome. And it kind of goes to hiring too. I mean, we've talked about that a lot at our firm, how people it's so easy to get stuck in your circle of the people you know from your social world. And you really have to force yourself sometimes to get outside of that world, your social world, or your particular group of litigation, your comrades in your particular litigation. And like you're doing with your podcast, learning from people in different practice areas in different regions, people of diverse backgrounds, there's just a huge advantage to that. And again, I think it's comparable to what we think about with hiring as well.
And I can tell you, of all the cases I've tried, the best verdicts, and I will never try a case again unless I have a female co-counsel, because whether we like it or not, men and women just think of things differently. We look at things differently. So why wouldn't we want both views sitting at counsel table? I mean, it makes no sense to not have it. The last thing we need are two of me's trying a case for a lot of reasons, actually. That's the last thing we need.
I joke with Brian that one of his last trials, not the most recent one, but I think the one before that, I was like begging and pleading with him to at least change his attire, because when you're sitting in the audience, there was a series of about seven white men with gray hair wearing gray suits every single day. I was just like, something to break the monotony. They were all doing an amazing job, and Brian put on a great trial. But we always joke about that scene, like you could just paint a picture of the gray.
It's true, though. It's true. And we'll have you guys back on where we can really delve into that a little bit more, because I think it's really important. It's the future, because unless we make those changes, there is no future for lawyers or trial lawyers. But we're here to talk about witnesses, and that everybody takes for granted. Oh, there's 3 people on a police report, no big deal. Let's depose them and be done with it. And I know you guys have a different approach of how you look at and why you look at witnesses. Why don't you tell us a little bit about that?
Sure.
Leah, do you want to start? Yeah.
Sure. So I think essentially, Elisha and I both are huge fans of preparing the fact witness. And we know that everyone tends to put their most green associates, their most green attorneys on these depositions to defend them. And that's okay. But if you're going to do that, they need to be prepared. They need to know what they're going into. I tell all of our attorneys, I never want to hear you blaming the witness. I never want to hear you say, oh, that witness was so bad, because there's always more you could have done to prepare the witness. Yes, some witnesses are naturally better than others, but it's our job as attorneys to work with whoever comes through our door and to prepare them for that deposition. And so I think Elisha and I are just going to talk about the ways that we've done it over time, how we are able to prepare sometimes even the most difficult witnesses, and just what that prep looks like.
So Elisha, so you guys are saying that you just don't meet the witness 20 minutes before the deposition and say, hey, just tell the truth, don't worry about anything, this will all go well. That you actually do more.
We actually do more. And it starts with interrogatories and in discovery and getting to know your plaintiff, you know, even before you file the complaint, and just understanding sort of where they're coming from. And one of the things that I was talking with Leah about is it's so important. I learned when I did products work that to go to your plaintiff's house, see them in their environment, because what I think is so important for the jury to hear, especially when you're dealing with an injured person, is how their life has changed. And that's a really big concept for a lot of people. And so to break that down into little vignettes, specific examples that a jury can relate to, can be really hard for your client to think about. And so I remember once I went to a client's house. He was in a pain pump case. It's where we were saying that the use of the pain pump had ruined his shoulder, and so he could no longer do his job anymore. And so I was talking to him about how his life had been impacted by that, and he was giving me like these really big things, like, oh, I'm devastated, I can't do anything anymore. I get to his house and I see the ceiling fan is like hanging off the ceiling. Like, what's going on there? Oh, I want to fix that, but I can't lift my arm above my head. And like little things like that help them put into context their injuries, into, translate it to normal life.
Yeah, and I've heard that from other people. The big time trial consultants would say you're trying to find your witness's story. Mm-hmm. And by going to the house, you can kind of start finding that out. Is that what you guys think is going on?
Yeah. There's that, and then just talking to them over the phone. And often the more that you talk to them, the more you start to find where their skeletons are, because it's the part where they shrink away and they just want to gloss over something or avoid talking about something. Whenever a client wants to avoid talking about something, that's when you need to really dig in. And
so like what types of things do they avoid? Have you found clients tend to want to avoid talking about?
Well, for me, so this actually goes into one of the biggest areas of witness prep for us is fear and guilt. And one of the things that I've noticed with family members of people who have family in nursing homes is, they feel guilty about having put their loved one in a home to begin with. And sometimes they have on top of that guilt, there's some kind of estranged relationship where, the son doesn't want to admit that he and his mom didn't even get along before she went into the nursing home. And then you find out that there's this a lot of marital strife that led to estranged mother-son relationship. And usually it's that kind of thing where they don't think it's a big deal necessarily to talk about, but defense attorneys, when they sense fear, they
go for the kill.
Yeah.
Well, let me ask you this, Leah. How do you get your clients to understand that is not a bad thing, the guilt, and that's part of their story, and they should embrace it and talk about it?
I think it takes time, and I think it's about the trust that you develop with the client. Some of it depends on the type of case and what type of guilt or fear you're dealing with. But Elisha is saying it starts with interrogatories, and then beyond that, we always say 2 to 3 prep sessions at least. And it varies a little bit on the type of case that, the type of case and practice that you have. But for most cases, I think 2 to 3 prep sessions for sure, of them getting comfortable with you, getting comfortable with the process. We always do mock questions to give them practice in that setting. I know some people like to videotape that session and play it back, but in terms of the sort of guilt and getting them around that, I think it's just helping them understand what the case is about. And Elisha, I think actually you addressed this really well. It's in terms of whose job it is to do what, right?
Yes, I like to, well, first of all, like Leah said, we do 3 preps. The first prep is getting out all of that stuff. Like, what are you worried about? Like, what do you think is going to happen in a deposition? Like, what do you anticipate? And then it's, okay, well, this is your job as a witness, and this is my job as your attorney, and this is the defense counsel's job and the court reporter's job. And if you start talking in jobs, right, then it's very easy to transfer into that, the end of the second day or the third day of prep. We're like, okay, let's go through all of your guilt as a mom, right?
Right.
What was your job as a mom to protect my baby? How did you do that? How did you do your job? All right. And what was the job of the doctor? And then oftentimes, you know, the feelings of betrayal come out. I was betrayed by my doctor. I trusted my doctor. Right. You did your job. What job did the doctor have to do? And if you frame it in jobs, that's really easy to remember, so that no matter how the defense is trying to you know, turn it on them, they can always go back to, no matter what question you're asked, think about what was my job and what was that job, their job.
You
right?
just said the two key words, I think, and I know you're fellow nursing home warriors, so I have an affinity when I get one of my people on the podcast. As everyone knows, that I tried nursing home cases for 30 years, but betrayal and trust is what these cases are about. Even if we never say the word, we don't have to. When the plaintiff tells their story and said, but the nursing home said they'd be able to take care of this, you know, they're not doctors. The daughter's not a doctor. It plays the betrayal and trust. I'm interested in what you both think about this. Another client of mine is about to start a trial, and he indicated to me that the defense lawyer is known for playing the David and Goliath story, with the surgeon being David. I'm not sure how this works, and the plaintiff being Goliath. That this defense lawyer, tends to have nothing on her table but a legal pad, and she's rather diminutive in stature, and she tends to play to that. I said, I think if she does play to that, you should be playing the betrayal and trust issue, because in my view, that always is going to trump David versus Goliath. I don't know how you two feel about that.
Yeah, I mean, definitely. And I think, I mean, I'm just going to go back. The easiest way to do that is to remind your client of what their job was, you know, and what the doctor's job was. And it's very easy for them to say, but you didn't do your job. I did my job. You did not do your job. And I think, you know, you can keep it simple like that.
I think that's pretty compelling. So Leah, you have your first meeting with your witness, with the plaintiff. What goes on when you first meet for that first meeting for the prep? Not the first time you meet them, but the first time you meet them for the prep.
The first prep tends to be more logistical, of explaining the process. And again, because the reality is many of us do send our newest associates to these depositions. And again, I think that's okay, but they just have to be prepared. We actually have like an outline or a checklist. Like these are all the things that you must cover in that first session, because I used to work in a practice that was a little bit more volume based than what we are now. And, you know, for young associates, they're just defending so many of these depositions. And I think it's so easy just to think, oh, I've done this a million times, and just to walk in and feel like you can prep somebody with no preparation at all. And, you know, without fail, you always forget like some important piece to address with the client. So I think it's really important, you know, you don't have to have a script, but to have some type of checklist to make sure that you're just covering all the basics that they need to understand about what a deposition is going to look like, what the rules are, what it's going to cover, and then to start warning them about some of the topics that may be more difficult. I think you can do that as well in the first session. But I don't know about you, Elisha, but I tend to, you know, really just go through the logistics and that's type of preparation during the first session.
So now you have your plaintiff there for the first session. You send them home. Do you send them home with any homework?
I do, and sometimes it's before the first one. I want all of the guilt, like, you know, because usually we get into like, you know, what's holding you back, or what are you most worried is going to come out in your deposition. Like, let's get all those fears out and then come back with that. And sometimes it's also to do that. When I talked to you about the guy with the ceiling fan hanging off his ceiling,
right?
Sometimes the homework is, I want you to go home and I want you to think about, as you're going through your day, every little thing that is more difficult for you now than it was before, and write it down. Because a jury is going to relate to somebody who, you know, as opposed to saying, oh, I can't garden anymore. You say, oh my gosh, it took me 3 hours to do one little thing yesterday, when usually it would take 15 minutes, you know.
How about you, Leah?
Later.
How about you? Do you send your client home with any homework?
Yeah, absolutely. And I think it's just about getting their head in this place so that they're starting to think about things so that the next session will go well. And it depends a lot on the type of case it is as to what questions you're going to send them home with. But I think absolutely, you just want them to start thinking about all this stuff, you know, recollecting things as much as possible over these couple of weeks that you're prepping them for.
So now I know that both of you are handling nursing home cases all over the state. Do you go out of state to handle cases, or are you just in Maryland?
We're licensed in Maryland and DC.
Oh, okay. So now you have, in most cases, the plaintiff isn't the injured, isn't the person who damage was done to, but it's the daughter, the spouse, the children. How do you, is it a little bit different when you're dealing with those people on that first meeting?
So from my perspective, there's a lot more of that guilt, like unpacking the guilt and finding ways of like, okay, so you have a really stern mom who, or maybe the mother had a mental illness, right? And so the upbringing was really difficult. So what I find helpful is, and sometimes your client wants to throw them under the bus, you know, it's weird.
Yeah.
Like sometimes they want to get out that my mom was a real hard ass, you know? And so there's a way to do that where you're like, okay, listen, give me 3 words that you can say that describe your mom, that get that message across, but in a way that is helpful to our case. Like, how can you say all that, but differently? Like, you know, she had convictions. Like she was, you know, education was important, religion was important, and she had convictions.
Yeah, that's all our mothers at our age.
Yeah. Some had more conviction than others.
Sometimes we'd use the phrase stern, but which I think is okay. I don't think that's a problem. Interesting.
They were impressed upon me daily.
That's interesting. Leah, how's it different for you, if at all, with when it's a family member as opposed to the person who, you know, fell and broke their hip?
Yeah, I mean, to be quite honest, in most all of the cases I've ever handled, it's usually not, well, it's often not the injured person that's the main witness. I spent a lot of time representing victims of lead paint poisoning. So they're the primary witness is the mother. And again, I mean, Elisha and I have talked about this a lot lately as we were thinking about this podcast, just how important it is to build that relationship and talk through things with them, because one, they're not going to know what's important, right? So you have to just learn their story and hear their story in order to help them think about how to craft it. But so often they're just, you know, terrified to tell you the reality of what happened, and they're ashamed. And it just takes a lot of work to help them. So I don't know, what was the phrase you said, to craft their story? Or yeah,
I mean, that's really what you're doing.
Yeah, I mean, because in those cases, you prove your case by showing that there was chipping, flaking, and peeling paint that peeled off and landed around the house that then the children were exposed to. And you'd be amazed how many mothers just are terrified or so ashamed of admitting that they weren't wiping the windowsills daily, and therefore the chipping paint was allowed to accumulate. And it takes a little bit of time to work through that. But yeah, it's all the same type of work. I think it's just slightly different in each different type of case.
Yeah, because in the nursing home world, it's, you know, how did I not know my mother wasn't being cared for? How did I not know they weren't turning her?
How did I choose this facility?
Exactly.
Why was I not there enough?
But that's their story, really. And that's really the story that we have to tell the jury, because, you know, the jury's going to be thinking that would never happen to my daughter, or that would never happen to my mother, because I would never let it happen. And we have to show that, you would, because
it happens.
Yeah,
it happens every day. Yeah.
So now we have the second meeting with the client. How does that go? Well, what do you talk about there in the second prep?
So for me, the second prep is just get it all out on the table. Like, let them tell you everything. Hopefully they understand the deposition process a little bit, and then they've done their homework. So they've started to really relive the details of the events, and they have all that information at the forefront of their mind, and they want to start talking. And I want them to talk about it as much as possible, because I want them to get it out now so that they feel comfortable with it, so that when they're in the room later being deposed, they don't feel like they just need to spew everything. They feel like they've been heard and already, and so they can just focus on what's important. They can just answer the questions. They don't feel like they need to justify themselves and start at the beginning and end at the end, because they've already done that with me for a really long time, usually during that second prep session. And
oh, that's great.
Yeah, time and time again, the more that they get to tell you everything, the less they feel the need to, this is a term I've heard other attorneys use and I hate it, but the less they feel the need for that verbal diarrhea,
yeah.
for just like spewing and spewing, trying to get everything out, because they want to feel, they want to get their side of the story across. If they feel understood by you, then they're going to be able to just answer the questions and stick to answering the questions much, much better.
Boy, that's a great idea. And you're forming a bond, because you're letting them talk and you're not correcting them. You're not changing them. You're just letting them go. That's great. How about you, Elisha? How does your second day of prep go?
So it's largely similar, and what you just said about forming that bond is so important. And I make a point of telling them, you do not have to win your case. The deposition is not a place to try and win your case. That's not what is happening here. But when it comes to that damage question, I want you to talk for days about all the ways that it's impacted you. And that's when we go through all the questions. We practice. If you have questions if you know who's going to be taking the deposition, you can pull out one of that attorney's deposition transcripts and run through some questions with them. Sometimes they have no clue that why am I in a nursing home case talking about where I went to high school? Like, you know what I mean? Like having the idea that you have to be able to recount all the places you've lived for the past 10 years and, getting them
all those important questions that the defense lawyers normally ask.
Right.
Where the daughter went to high school could be very important in the jury trial of that mom.
Yeah, but that's a good point, Saul, because what happens is you have to prep them not to burn out, because the important questions come at the end. So don't let yourself get exhausted.
And I used to always tell my clients, look, if the defense attorney has to leave here thinking one of us is an ass, let it be. I'll be the ass. You be, she's such a nice woman. I don't know how she deals with that lawyer, that ass. And then that kind of relaxed them, because my clients always knew I could be an ass. So it worked out well.
I think that, Elisha, what you said about the damages is so important, because I think people don't always have the concept of how much you can say and how much they can elaborate about that piece of it. And you really have to practice that and rehearse it and add more detail. What about this? And like you say, going to their house or really knowing the medical records or the family history can help draw out that information. But also sometimes in the nursing home cases, the med mal cases, and other cases, it's gory and it's ugly sometimes, and it's not comfortable, and they need practice with that. And Elisha, I think often about the prep that you did largely in a bowel perforation case that we had recently. I don't know if you want to speak to that a little bit, and just how hard it was to just get her comfortable talking about what her life was like after that.
Yeah, that was prepping for a trial, and we had some depositions taken already, so we knew sort of what the ugly parts of the case were going to be. And so I guess the way that we approached that was I had my direct sort of mapped out in a way that I thought it should come out based on the deposition testimony and the story we were going to tell at trial. But then when I prepped her, I was not of course you don't share your questions with them, but I did take her through the whole outline and pull out from her the really devastating parts of in her case, she felt terrible as a human because she was living with her mom she wasn't living with her mom before she was injured, but after she was injured, she had to go home and live with her mom. Her mom had a bunch of health problems herself. and her colostomy bag was spilling out all over the kitchen. She was having to mop it from a wheelchair. She was embarrassed to do that in her mom's house. There was a lot of guilt, and it strained the relationship with her parents. And so we had to work through that in the prep to get it all out. And, part of it is
feel comfortable and also not at the same time not feel like contrived about,
Yeah.
That's the hard part, right? Is when somebody starts talking about themselves, it can be contrived so quickly, and the jury could say, "Oh, boo-hoo." How do you guys walk that tightrope?
So I think the way to deal with that is not letting them say, "Woe is me. I had such a hard time." I can't, like 3 times I had to wipe my, colostomy bag spillage off the floor. Like, they get that through talking about the things that actually, you don't have to say it when you can demonstrate what happened.
Right.
That's
putting
the best
the actual
way.
facts and using photographs or et cetera. Yeah.
Yeah. And in that case, she had an estranged relationship with her sons too. And so in talking with them, I knew there was like some strife between like the son and his wife and his mom.
Ooh.
And so to get through that, we talked about, but she was a great grandchild, right? A great grandmother, right? And so we emphasized that piece of it.
I mean, there's always a story. It's just hard to find it sometimes. And I guess that's why you need the 3 preps, because you're really finding the story. I know Catherine James just came out with her new book. I don't know if either of you've seen it yet. I've known Catherine for years, just from my work with the Nursing Home Litigation Group of AAJ, where it's finding the witness's story. And we're going to have her on a little bit, probably next year. And she's going to talk about that as well. And she says the same things you guys just said. You have to go to the house. If you don't go to the house, you're never going to find the story, because you have to make your witness feel really comfortable. And a lot of times, like you said, Elisha, you get your story just by seeing the fan falling off the ceiling.
Yeah.
So now it's your 3rd prep. Is that when you do the questions?
I do the questions in the second one, and then maybe in the 3rd one, we do like a cleanup. Like, so in Leah, sometimes you record them, right? The second time?
Yeah, I have recorded, like done mock interview questions and video recorded it a little bit in the second session, and then gone back to that in the 3rd session. And 2 to 3 is not a rule, by the way. It's,
right.
But a minimum 2 to 3. It depends again on the type of case. So yeah, if you've done those mock questions, I would say that definitely start that process in the second session. And then, like Alicia's saying, you can clean it up and you can come back to it and make it easier during the 3rd session. I definitely like to go through any information I can provide about the attorney, I think, who's going to be taking it. I like to give all that information in the 3rd session. I don't know. We're in Baltimore where we all know each other.
And I was in New Jersey where we all knew each other, and we knew who was going to take the we could even do the deposition for them, because there was only so many of us that had these cases. And
there's a couple of them in particular that, I feel like I really need to prepare the witness for their particular style.
Oh, yes. Yeah.
And it's always the ones who try to become their best friends, and you have to just prepare them that, it's gonna seem fun at times. It's gonna feel like chatting with a girlfriend, but that's not what this is. She's not your girlfriend.
That's so important. Oh my God, is that important? I used to tell my clients, this is not a conversation. Don't get caught up in that conversation. It's a question, answer, question, answer. You don't have to tell them more than you know or less than you know, just answer the question.
Absolutely.
And to the point where when I was done the prep, in fact, my partners made me stop prepping my clients because they were so mad at me, because I would really go in for the kill. And my goal was to make my deposition easier than the defense attorney's deposition.
Absolutely. Yeah.
Now, and if you don't do it that way, I know a lot of people say you're crazy, that it's just a deposition. But if you don't do it that way and they're bad at the deposition, that pretty much ends what they can do to a large part of the trial.
Yeah.
Yeah.
Alicia's thinking, though. I don't know if I agree with you, Saul.
No, there's something that, no, it's not that I disagree with you. It's just that it's also that this is their chance to let the carrier know all about them, what kind of witness they're going to be, how, if the jury's going to like them, and sort of the gravity of their story. You know.
Now,
But you
Leah,
said you got some grief, Saul. I mean, did you ever have a time in your career where you thought, wow, I really should not have spent that much time prepping this witness? That really was a huge waste of my time.
not
No,
one
I don't
time.
think anybody's ever thought that. Yeah.
No, never. No, but I will tell you what I thought once a week. How could I have not spent more time with this particular person in prepping them? Absolutely. I mean, we don't spend nearly enough time with our clients in prepping. And the only people who spend less time than we do are the defense lawyers, at least in nursing home cases, with the witnesses. Yeah, I think med mal lawyers are a little bit different because they're like one and the same with their clients. But the nursing home lawyers, we could take 3 aides in one day, and they're prepping them. They've never spoken to them, and they're prepping them right before one of us is taking the deposition. And that's not going to go well for them. It's just not. Interesting. This is pretty interesting.
And people always talk about, every trial presentation you've ever heard always starts with be the most prepared attorney in the courtroom. And I've always wondered, why do we never hear that about depositions? Like, why should you not be the most prepared attorney, even when you're defending a fact witness? Because in some ways you could argue that the fact witness deposition, like Elisha's saying, sets the tone for the whole case. It's hugely important.
Well, you just said it.
Yeah.
Be the most prepared. I think you're absolutely right. And make sure
I got to say, I've been on the other side of it before, having done class action work where you have class representative plaintiffs. And so that's even more important. And the fact deposition's even more important there. But, it was many years ago. It was over a dozen years ago, probably. And I got slammed. Arnold and Porter was on the other side, and they did their research on our witness, on our class plaintiff, our class rep, and it was ugly. It was so ugly. I've never been more mortified in my entire life. It was a property damage case, and our person had been on some like blackboards or something in the internet 12 years ago that I didn't know easily how to access, and he had all of these like personal vendettas against our defendant, and he just came across as a Looney Tune. And it turned out that he had already gone through foreclosure beforehand, and we hadn't found that out. And that was hugely relevant to our claim, just all this stuff. And Arnold and Porter came in with boxes after boxes, literally boxes of his post printed out. And I was like second chair defending that deposition, but it was one of the most painful experiences of my entire career.
As trial lawyers, we're so controlling, right? We just are. There's nothing worse than sitting there and watching your witness, you say, go down in flames, and there's nothing you can do about it. Right? There's just nothing.
It was
start objecting over nothing, but it doesn't matter. That nobody cares what you say at that point.
Yeah.
No. And I think you're right, though. Leah, I think you said it. It's our fault. If that happens, it's our fault.
Yeah, we hadn't done enough research, enough digging. Mm-hmm. We hadn't talked to him enough. And, Elisha talked about going to the person's house to do the deposition prep, but it's also, to get the discovery. I mean, I think firmly that you should be in their house helping them. Oh, so where did you keep your medical bills? Or, what are your photographs? Or where might the brochure from the nursing home be? Oh, you have a file cabinet over here. Did you keep any documents there? Literally just walking around their house and seeing where documents, photographs, relevant materials may be stored, and you'll be amazed like how many documents you'll find that you could then produce and could be really helpful to your case.
Wow.
Yep.
Now, Leah and I both belong to an organization that values systems and streamlining from a business point of view. And they try to, from what I see, have non-lawyers do as much as they can, whether it be paralegals, secretaries. Do either of you believe in a paralegal or a secretary being able to help prep a witness before their deposition, a plaintiff?
Well, I'll tell you, we have some paralegals who can do that background research better than I could ever dream of doing myself. So some of them are really good at, just pulling all the information you could possibly need about the witness and their family, et cetera. But Elisha, what were you going to say about the actual prep?
Well, I was just going to say, if you think about your prep, deposition prep really begins with the case, right? So when our paralegals are talking with the clients, we make sure we have open communication with the client so that the paralegal is talking with them a lot before, the attorneys get the file. When the attorneys get the file, the paralegal is setting up calls with the client. So I think if you think about your deposition prep in terms of just contact with the client and learning the story, then absolutely the paralegals are involved in it, whether they know it or not, and whether you call it deposition prep.
But the actual prep that we're talking about, it's got to be you as the lawyer.
It's got to be you, yeah. And I think the same with the discovery. Like, I don't want my paralegal doing all the discovery. I think of, formatting it, putting in the basic stuff, fine. But you have to be talking to the client about that basic stuff.
It's funny.
I think that goes to sort of our theme for the day, Saul, which is just that, this stuff matters, and it's so easy because you don't usually lose the case here, but you could win it, right? Like, you could win your case at your client's deposition, but it's so easy, I think, for firms to just slough this stuff off and not take it that seriously and put really junior people on it and not pay a lot of attention to it. And I guess what we're trying to talk about today is that if you treat it as importantly as you could, you'll get a lot of value out of it.
I used to do the W's with my clients.
Yeah.
The who's, the what's, where, when, and ask for every fact, how do you know that? What did it feel like? What did it smell like? Which in a pressure ulcer case may make a difference. I once had we found out after talking to our client, and it was actually Victoria Shaw, who I mentioned earlier, one of the lawyers I used to work with, said to her, well, did you hear anything? And she was actually talking to an aide, not our client. But the aide said, yeah, I was in the room and I heard your client fall. And Tori said, well, how do you know she fell? Well, I heard it, and then I heard her head hit the ground like a bowling ball hitting the ground. And that became, of course, at trial what I brought, because it's, you don't have to, it's not hard to know that I came in with a bowling bag. Now I didn't have a bowl.
If he had not asked that question, then that anecdote may not have come out at deposition.
No, I don't think it would have, which is why I say when it's our client, we should be asking all of that. Just because they say it hurt, why hurt? Like what?
You want those vivid details. Yeah.
And I think if you do that in your prep, they're going to be more comfortable with it, especially if you take your firm's 3 prep rule. By the time they're being deposed, they're going to be very comfortable with it, and that can become your story and your theme. How did it hurt? What did it feel like? What did it look like? When you're passing, if it's a nursing home case, when you're passing when you first step into that nursing home, what do you hear? What do you see? What do you feel? What do you smell? I mean, it's incredible, those senses, if you do that with your client all the time, how they're going to be much more attuned to it during the deposition.
That's awesome. And I hadn't thought about that before, especially like the what did you hear and what did you smell? But I have to tell you, what you just said reminded me of something that came up in one of our last depositions, is what happens when the nursing home that you're dealing with is one of the best or renowned in the state, and you walk, and your client, or not even the client, it is the client, the witness is going to come in and say in the deposition, it was pristine. There was never a piece of paper, a paperclip on the floor, nothing. And that, I feel like the way we attack that is back to that betrayal. So you trusted that they were going to do their job. And so that's how we handled that.
Whether we know it or not, whether we think it or not, trust and betrayal is a cornerstone of every one of our cases, no matter what it is. If it's a car accident, you trusted the other person to follow the rules. They didn't follow the rules. Obviously, if there's no relationship at all between you and that other person, the betrayal becomes difficult. But as long as there's any type of relationship, even if I purchase something from somebody, without knowing it, trust and betrayal really is the core of a lot of our stories. And that's how I always prepare my clients that way as well. Well, this has been great. Any other tips you can give everybody in preparing your client for the fun deposition? So one last question I have for you. Do you ever videotape your own client's deposition? We lost Elisha.
I have not done that, but it's because oftentimes the defendants are videotaping.
Yeah, I think that routinely they just get videotaped usually by the defendant. So I guess I haven't thought about that too much.
Okay, I didn't realize defendants were now doing the videotape. I know we as plaintiff lawyers have been doing that for years. Defense lawyers always seem to be about 10 years behind us on things like that. Like I never understood why they wouldn't videotape a plaintiff's step, especially if it's going to go well for them. They could replay it and the whole case is over. Do you ever discuss, and I'm sorry I'm going a little longer than I thought we would, but that's the story of this podcast. Do you ever discuss with your clients their likability factor and how important that is?
Always. I always do.
And what about you, Elisha?
Absolutely. It's the first thing and the way it comes out is, what do they expect is going to happen? Why are they being deposed? And I always say, this is the defense opportunity to see what kind of witness you are going to be. Is the jury going to like you? And I always use the story of, if you're walking down the sidewalk and you have a smile on your face, people are going to gravitate toward you. If you look surly, they're going to stay away. And so everything about the deposition matters, and it's not like how you're dressed, how fancy you are. It's it's your face, like how you tell your story. And
because that's really what's going to happen in front of the jury, right?
And I think it depends a lot on the types of, again, I keep saying this, but the types of cases and the types of clients you're dealing with. But I mean, some of our clients, if they're from, particularly difficult circumstances, it's in their nature to become oppositional to some of these jerky defense attorneys. And that's something that I've, with some of my clients, really had to, hit home with, that you can't do that, and explaining why and telling them why I believe in them, that they're not going to, especially 20-something-year-olds, that they're not going to go down that road, and how we're going to prevent that, and how I'm going to help to make sure that that doesn't happen, and why it matters,
Because it really does matter. I mean, I think if the carrier is told that the witness is a surly person that the jury won't like and has a feeling of someone owes me something, that could be the difference between a settlement and a trial.
Absolutely.
Or if the defendant thinks they can create a circus with the family members.
Well, that's certainly in a nursing home case always.
Yeah.
It's one of the issues I always do. I try to avoid the family. If there's families fighting, I normally I would not take that case. Because they're difficult. Because if the families aren't even getting along, of course they were left alone at a nursing home and no one's caring for them. So, well, thank you guys. I really appreciate you coming on. We really enjoyed it. Again, it's Elisha Hawk and Leah Barron out of Baltimore, two phenomenal trial lawyers. And I am Saul Gruber from Gruber Trial Consulting. Thanks, guys. I really appreciate it.
Thank you.
This is Saul Gruber from Gruber Trial Consulting, and the podcast is The Jury Thinks What? I want to thank both Elisha Hawk and Leah Barron from Brown Barron giving us some incredible tips on preparing our clients for depositions, things we don't often do, and we really should do, going to their home, preparing them on 3 separate days, and really helping them find their story before the deposition. That will go a long way to making your cases a lot better, and more importantly, getting justice for the people who need it the most. We now come to the part of the podcast where we talk about a nursing home tip for this podcast. And this tip is something that I don't know that everybody does, and they absolutely should do. The first time you get the nursing home records, and maybe you'll get a hospital record to determine whether a claim exists. Also get the EMS records, the ambulance records from the nursing home to the hospital. They can give you a lot of information that you didn't realize even existed. That information could be admissions by staff at the nursing home. It could be what the ambulance drivers see in a choking case, in a fall case. It could be almost anything. It could go directly to the pain and suffering, but you don't know it until you get it. That will also give you perhaps additional witnesses to sway the jury in your client's favor. And if you're a regular podcast listener, you know I am originally from New Jersey and a very huge Bruce Springsteen fan. And I try to find different quotes that trial lawyers can use in their cases. And for today, in a wrongful death case, I choose Empty Sky off the Rising album. And the quote is, "I woke up this morning, I could barely breathe. Just an empty impression in the bed where you used to be. I want a kiss from your lips. I want an eye for an eye. I woke up this morning to an empty sky." Think about those words and think about how you can use the phrase empty sky, perhaps in your closing, maybe in your opening, and tie those words to the loss of hope, to the need, to the yearning that someone has when they lose a loved one. Think about that, and if it's not that quote, think about something else, because you must get your story across if you're going to win your trial. Again, this is Saul Gruber from Gruber Trial Consulting on The Jury Thinks What. We're part of the Lawyer Minds podcast team. Look for some of the other podcasts out there by Tad Thomas and Michael Campbell. I think you'll find them very enjoyable and perfect for your practice. Thank you.
That concludes another episode of the Jury Thinks What podcast, part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.